India's economic development, driven by rapid industrial growth and urbanization, is causing severe environmental issues that have impact on local, regional and global environment. With rapid industrialization and urbanization in India's leading to boom in metropolises and straining the limits of municipal services and causing serious environmental problems such as deforestation, soil erosion, water pollution and land degradation. In India, more than 20 cities have populations of above 1 million and states like New Delhi, Mumbai, Chennai and Kolkata are among the world's most polluted ones. Assuming this continuous economic liberalization and increased urbanization, the damage to environment and health could be massive if cautionary measures are not taken. Therefore, the challenge is to maintain the quality of air, water and land and safeguard the environment by integration of environmental, social and economic imperatives. Learning outcomes. After starting this module, you shall be able to know about national policies for environment, know about National Environmental Regulation Policy 2006, know about enforcement of policies. Let us understand the role of Constitution and various national policies for environment. India has taken a bold step to embrace environmental protection rights and duties in its constitution. The Constitution of India stipulates that the government shall attempt to protect and improve the environment and maintain the natural resources of the country. According to the Constitution of India, it is the fundamental duty of every citizen of India to protect and improve the natural environment and to have compassion for living beings. By hovering environmental concerns to the constitutional level, India has provided its people with a powerful policy tools to protect the environment. National policies. Along with the constitutional mandate, India has also started a number of national policies governing environmental management, which includes the National Policy on Pollution Abatement (NPPA) 1992 and the National Conservation Strategy and Policy Statement on Environment and Development NCS/PSED 1992. However, these policies serve as guiding principles for the central and state governments to follow, as they are not judicially enforceable. The NPPA enforces the traditional command and control approaches to pollution abatement. The policy adopts the following guiding principles: avoidance of pollution at source, adopting the best available technology, the polluter pays principle and participation of the public in decision making. The NCS/PSED provides a predominant policy framework on environmental management, which includes conservation of natural resources and economic development. Its key instruments are assessing environmental impact, providing educational campaigns and ensuring public participation. The Ministry of Environment and Forest (MOEF) is responsible for implementing the NPPA and the NCS/PSED. National Environment Policy of 2006. The National Environment Policy (NEP) of 2006 is the most recent pronouncement of the government's assurance to improve environmental condition while promoting economic affluence nationwide. Its key environmental objectives include preservation of crucial environmental resources, intragenerational equity, incorporating environment in economic and social development, livelihood efficiency in environment resource use, environmental management and enhancement for environmental conservation. This policy encourages mainstreaming of environmental concerns into all development activities, advocates the important environmental principles and also identifies the regulatory and substantive reforms. With respect to regulatory reforms, the NEP recommends a policy framework to develop synergies among relevant statutes and regulations, eliminate obsolescence and amalgamate provisions with similar objectives. The NEP has developed a new framework for legal action that includes solicitation of a mix of civil and criminal sanctions, adoption of innovative economic instruments, and public-private partnerships in consolidation with environmental compliance and enforcement. The MOEF is responsible for implementing the NEP. Next, moving on to the legal framework. India has an enormous laws relating to environmental protection. The main laws for the prevention and control of industrial and urban pollution include the following: Water Prevention and Control of Pollution Act of 1974 amended in 1988. Water Prevention and Control of Pollution Cess Act of 1977 amended in 1991. Air Prevention and Control of Pollution Act of 1981 amended in 1987. Environment Protection Act of 1986 EPA. Public Liability Insurance Act of 1991. National Environmental Tribunal Act of 1995, National Environmental Appellate Authority Act of 1997. The Water Act vests supervisory authority in state pollution control boards to establish and enforce effluent standards which facilitates discharging of pollutants into water bodies. The Central Pollution Control Board harmonizes activities between the states and performs these regulatory functions for the union territories. The central and state boards were accredited to control domestic and industrial discharge via consents to establish CTE and consents to operate CTO. Also, these boards advise state governments on setting of industrial projects. The Air Act offers for the prevention, control and abatement of air pollution. Its framework is similar to that of Water Act. The Air Act has the power to the state and central boards to issue consents to industries operating within entitled air pollution control areas. States also recommends emission standards for stationary and mobile sources. Next is key institutions. The key institutions responsible for the formulation and enforcement of environmental acts and rules include the Ministry of Environment and Forest MOEF, the Central Pollution Control Board CPCB, State Departments of Environment, State Pollution Control Boards SPCBs and municipal corporations. Ministry of Environment and Forest. The Ministry of Environment and Forest is established in 1985. The MOEF is the central government nodal agency. It is responsible for planning, promotion and coordination of all environmental activities including formulation of national policies, standards and regulations. The objectives of the MOEF are preservation and survey of flora, fauna, forest and wildlife, prevention and regulation of pollution, afforestation and regeneration of degraded areas, protection of the environment and welfare of animals and other living beings. Next is Central Pollution Control Board. Under MOEF, the Central Pollution Control Board CPCB is the national board which gives powers to oversight the state boards. The CPCB has a central office as well as a network of zonal offices located in New Delhi, Calcutta, Shillong, Kanpur, Bangalore and Vadodara. It is established in 1977 under the Water Act. The CPCB has wide range of powers and responsibilities which includes recommending the central government on any matter related to the prevention of and control of water and air pollution and also the improvement of air quality. Planning programs among nations for the prevention, control and abatement of water and air pollution, coordinating the activities of SPCBs and resolving dispute among them, providing technical assistance and supervision to the state boards, carrying out and sponsoring investigations and research relating to problems of water and air pollution and for the prevention, control and abatement, prosecuting polluting industries pursuant to the Water Act, collecting, compiling and publishing technical data on air and water pollution and the measures recommended for the prevention, control and abatement, organizing training of staff involved in environmental programs, preparing manuals, codes and guidelines relating to industrial emissions and effluents, organizing mass media awareness programs on environmental protection, disseminating information on water and air pollution and their prevention and control, and performing such other functions as prescribed by the central government. The total number of employees in the CPCB is approximately 500, out of which 100 have technical training. The CPCB has approximately 60 inspectors all over the nation. Next is State Pollution Control Board. The SPCBs were established resulting the state legislature's adoption of the Water Act of 1974 and then the Air Act of 1981. At the state level, the SPCBs are attached either to the Environment Department or to the Forest and Wildlife Department. In general, SPCBs perform the following functions: advising the state governments on pollution related issues, planning a widespread state level pollution control, prevention, abatement program, implementing and enforcing national standards by making them more stringent if warranted by local conditions, granting consents to form and to function under the Air and Water Acts and authorize hazardous waste disposal per rules under the EPA, and collecting water cess for the use of water. Role of the judiciary. Over the last 20 years, the Supreme Court of India and some high courts of the states have directed the way in the implementation of environmental laws through citizen-led public interest litigation (PIL). Through this judicial activism, the courts have issued orders with specific implementation requirements that have set new policies and practices with extensive implications for the regulated community. Also, all environment related fines and imprisonment are provided under criminal law and must be imposed by lower courts. Next, we shall discuss enforcement of environmental policies. Legal Enforcement Authority. The compliance, monitoring and enforcement is mostly done by SPCBs. Few direct enforcement actions taken by the CPCB are generally done by the zonal offices. Under the Water Act, the Air Act and the EPA, these boards have the authority to issue and withdraw consents to operate, require self-monitoring and broadcasting, conduct sampling, inspection, require corrective action and propose compliance schedules. The enforcement powers given to these boards include emergency measures of disengaging water or power supply and facility closure, and is widely used in some states. With CPCB approval, SPCBs can impose administrative fines for any violation of those rules. This provision of enforcing penalties for illegal shortage of hazardous waste is used in Maharashtra. The environmental tribunals came into existence with the 186th report of India's Law Commission September 2003, which has exclusive jurisdiction with regard to environmental cases. According to the report, these environment courts must be established to reduce the pressure and load on the High Court and the Supreme Court. All powers of a civil court in its original jurisdiction would be exercised by these environmental tribunals. They would also have appellate judicial powers against orders passed by the concerned authorities under the Water Act, the Air Act, the EPA and other environment related acts. At the national level, there would be a National Environmental Tribunal with corresponding tribunals at the state level. Next is key challenge. The effectiveness of PCB's enforcement efforts is bounded by the lack of civil administrative authority to impose fines and leads to over-reliance on the judiciary for enforcement. Filing criminal cases against violators in trial courts or reacting to bills is a time-consuming, unpredictable and ineffective enforcement mechanism. Institutional arrangements and capacity building. The CPCB have primary enforcement authority for union territories, while the same function is performed by for SPCBs in the states. The SPCBs have further delegated some implementation responsibilities to their regional and sub-regional offices. The CPCB's role is to synchronize activities among the states, and it provides technical assistance and guidance to the SPCBs. In addition, the CPCB may temporarily assume SPCB functions if a state board fails to comply with the CPCB direction apart from oversighting the SPCBs. There is also a coordination issue between SPCBs and other state level government agencies that have some environment related responsibilities, including urban development, municipal waste, departments of transport with respect to mobile source pollution of industries, etc. Such interagency collaboration as a system is very weak. Key challenges. First, there is very less coordination between the CPCB and SPCBs due to the double subordination of SPCBs. State government's influence is also a factor, as well as to the lack of enforcement policies and procedures and comprehensive standard compliance. Second, funding limitations remain a strong challenge facing all environmental institutions in the absence of strong political will to address environmental issues. The differences in the financial status and sources of funding of the PCBs lead to inequitable treatment of the regulated community. A high dependence on fees can also lead to mixed incentives and priorities for the employees. Third, high level of human and technical capacity limitations are an obvious factor that impacts effective execution of all compliance and enforcement functions at all the levels of center, state and local bodies. Next, we shall discuss compliance monitoring, inspection, permitting and self-monitoring permitting. All polluting facilities are legally mandated to obtain from a respective SPCB a consent permit to establish CTE and a consent to operate CTO. As per the notification issued by the MOEF in September 2006, certain new industrial projects, activities or those trying major notifications also require a prior environmental clearance from the CPCB for category A or from an SPCB for category B basis the Environmental Impact Assessment EIA report. A CTE is granted after the study of the potential environmental impact and of the design of pollution control installations. Conditions for pollution control norms are part of a CTE. After verification of compliance with these conditions, a CTO is issued with emission and effluent limits basis industrial sector specific standards as well as self-monitoring and reporting standards. Industries involved in using hazardous, biomedical or municipal waste should also obtain a permission. Some states, for example Gujarat, issue consolidated consents for air and water pollution and hazardous waste based on common consent applications CCA. Others like Chhattisgarh issue authorizations separately. In short, only large and medium sized facilities have the necessary permits. Most small scale industries operate without any consents. The CPCB has recently drafted instructions for management of consent and authorization, which is to streamline the permitting process across different states and stipulate consent validity periods for different categories of industry, red, orange or green, based on their environmental impact. Currently, all states sets its own rules and consent validity time periods are varied between 1 or 2 years for highly polluting industry to 15 years for SMEs. Central and state officials spend a lot of amount of time and resources on permitting due in part to containing industrial growth. In Andhra Pradesh, the number of new facilities targeting for consent permits drastically increased from 611 in 2005 to 970 in 2006. Cases of consent denials are few in Andhra Pradesh. They constituted a meagre 2% of the total applications received. Inspection and monitoring are a key function of SPCBs. The number of trips of on-site visits to verify compliance is ascertained by the pollution potential green, orange, red and size based on the value of invested money of the industry. However, states seem to have different interpretation of the guidance and did not agree to it as binding. For example, red category facilities are mandated to be inspected once every month in Gujarat, once in a quarter in Orissa, and once every 2 years in West Bengal. In addition to inspections to monitor compliance, SPCBs conduct checks in response to complaints and also as part of the consent renewal process. Most inspections are multimedia covering air, water and waste and surprised. After inspection, inspecting teams submit written reports to best deploy resources. Some SPCBs are also trying to set priorities in keeping with annual plans that prioritize highly polluting areas, projects or activities. There are no standard inspection and sampling methods prescribed either in the Water Act, Air Act or EPA or their regulations, and the CPCB and SPCB have not made uniform guidelines. As a result, boards develop and use their own approaches and methods, which is not the most efficient way to use limited agency resources. For example, the deficiency of the sampling procedure is named as one of the main reasons why courts often do the ruling against the government. While the number of inspections conducted by different SPCBs is good enough, for example, in Andhra Pradesh, 24,565 inspections were carried out over the previous 3 years. Most SMEs are inspected rarely. In addition, given the number of facilities the few SPCBs inspectors have to visit, there is enormous pressure to complete inspections as quickly as possible, which restricts their effectiveness and causes poor detection of violations. Several SPCBs rotate inspectors within the state to reduce favoritism, causes demoralization amongst the staff, which is already overstretched. CPCB zonal offices can also conduct inspections associated with a national strategy, a special project within a zonal area, a court obligation or the environmental surveillance squad program. Zonal office inspections are normally more extensive than SPCB inspections and usually take several days to complete. US EPA 2005. Self-monitoring and reporting. As per the National Environment Protection Rules of 1986, each polluting facility must submit an environmental statement at the end of every financial year, April through March. The environmental statement must include the following information: air and water pollution discharged by parameter, average daily quantity and concentration, as well as percentage of variation from the prescribed limits. Water and raw material consumption, hazardous waste generation, total quantity from the production process and pollution control installations, and ways of disposal. Pollution abatement measures implemented. Solid waste generation, reuse, recycling, 1+ and disposal. The consents, prescribed measures and respective self-monitoring frequencies. All the procedures and requirements across states are not same. Lack of reporting or wrong reporting may lead to criminal or administrative penalties. Government agencies can only carry on with legal action on the basis of legal samples taken by inspectors who are certified to conduct inspections in accordance with specified procedures. The present legal framework, however, does not authorize enforcement actions through the legal system based on self-disclosed reports. As a result, not using self-reported information is a major constraint in promoting compliance and enforcement. Area-based environmental management programs. The area-based approach to environmental regulation has been used in India since 1991 through different CPCB and SPCB programs. For example, the CPCB and concerned SPCBs had identified 24 critically polluted problem areas, action plans for which, including compliance, monitoring measures, have been made and are in various stages of execution. Similarly, urban air action plans have been designed in 17 cities out of 53 identified by the CPCB, where air quality is better than the National Ambient Standards World Bank 2006. These programs have an advantage of focusing regulatory and compliance monitoring efforts of the concerned SPCBs. They so far have had average success in India, mostly due to the lack of coordinating efforts targeting industry, municipal, mobile and non-point pollution sources. Next, key challenges. Legal limitations on the use of self-monitoring data as evidence in court and other proceedings puts an additional monitoring weight on SPCBs and serve as a disincentive for industry to conduct correct self-monitoring and reporting. The lack of nationwide implementing guidance on permitting and compliance monitoring from the CPCB on issues such as definition of compliance, consent conditions, reporting format, sampling requirements and interpretation of different regulation significantly impairs the quality of SPCB implementing programs and limits the exchange of experiences between the states. SPCB staff spend most part of their time on issuing consents, whose validity periods are often unjustifiably short, at the expense of their compliance monitoring and enforcement responsibilities. Overemphasis of permitting, monitoring and inspection activities on industry in general and large industry in particular reduces SPCB regulatory programs to an important but not dominant pollution source, while the significant cumulative pollution impacts from SMEs contributing approximately 70% of the industrial pollution load, municipal sources, transport and agriculture are virtually disregarded. Let us now summarize what we have learnt in this module. India has taken a bold step to embrace environmental protection rights and duties in its constitution. The Constitution of India stipulates that the government shall attempt to protect and improve the environment and maintain the natural resources of the country. Along with the constitutional mandate, India has also started a number of national policies governing environmental management, which includes the NPPA 1992 and NCS/PSED 1992. Under MOEF, the Central Pollution Control Board CPCB is the national board which have powers to oversight the state boards. Over the last 20 years, the Supreme Court of India and some high courts of the states have directed the way in the implementation of environmental laws through citizen-led public interest litigation bill. In addition to inspections to monitor compliance, SPCBs conduct checks in response to complaints and also as part of the consent renewal process. Thank you.